Okay, Judge, we're live on YouTube now.
Okay, thank you. I hope we don't continue to have issues with that YouTube function. And so we are not on the record. However, I'm just trying to keep track of all the folks that are here already. We're still lacking a couple of people, Mr. Ferguson, Mr. Cox?
We're lacking Mr. Flores.
Okay, we can hold on just for a second. Unfortunately, this is something that I would probably say we can take a break off of YouTube and wait, but because we've had so many issues with that YouTube function today, I just assume leave the YouTube feed going. Feel free to mute, turn off your cameras. Just let me know I am here. Let me know as soon as we have everyone here that is necessary for the hearing, okay?
Is anyone else having trouble hearing all the audio? Or is it just my connection?
Mr. Briggs, I can hear you. Are you on the English function?
I did. I went down and I clicked on the English
Okay,
channel for the translation, but the audio is coming through really choppy. I'm only hearing about half of what the judge is saying.
You know what? I don't know if it's issues with the internet because I was having problems getting on the YouTube. Okay, so. But you're coming in loud and clear right now. You're coming in loud and clear.
And then my screen keeps freezing up, and I'm hardwired. I'm hardwired to the internet. This isn't a Bluetooth connection or anything, so I'm not sure if that's going to get any better or not.
Yeah, unfortunately, it even happens with the line, the regular line. So I'll just ask for anyone that has any difficulty in their feed, hearing what is going on, if you will please just notify us either by saying something or waving to let me know that you're not receiving a full and clear feed of the proceedings. So it happens, yeah. Mr. Briggs, can you not hear me?
Yeah, Judge, I'm getting about every. I can't. It keeps breaking up, and I've got a message that says my internet connection is unstable. But I'm hardwired in through the count. I'm in my office, and I'm hardwired to the internet.
It happens.
And I can't believe that it's still breaking up like this. So I'm not sure. I've only gotten about half of what you said.
So are you able to get on another computer?
I can go try another computer. Let me move to another.
Sure.
You know what? I'll go over to the conference room that we normally use for our unit stuff. So let me move over there, and I'll see if that's a better connection. Sure.
Is anyone else having that problem? Because it's not unheard of. I've had issues. I've had issues being on my hardwire or whatever you want to call it, wired connection computer where it does have internet issues. So is anybody else having problems? No? Okay.
I'm having a little bit, but that's okay. I think I can manage.
Okay. All right. So we'll just wait for Mr. Briggs. Okay, is Mr. Briggs logged in?
Show them on the screen, Judge.
Mr. Briggs, do you have a better connection?
I disconnected from the hardwired. I disconnected from the hardwire and then going off of the I guess the Wi-Fi, and it doesn't seem to be any better. So I'm trying to log in on another computer, but I'm having an issue doing that. So
Okay.
if I can figure out how to get this thing on another computer, I'm going to try that.
Okay.
Well, I tell you what.
Mute it and log in.
You could call and have us as, you can have your phone as, he's gone, right? Okay, well.
Is he gone? He's still there. Yeah, he can call in the landline for the audio and mute his video for him to view and be seen. So I don't know if someone's near Mr. Briggs that can help him with that. Okay, Chewy, I guess I'm a co-host and I admitted, I think Miss Hill, I'm assuming that's Mr. Briggs, potentially, and Miss Salazar. I don't know if she actually came in.
Okay, I believe the name changed to Ms. Hill.
Mhm.
Okay, Ms. Salazar, that's for, there, she's coming in.
Okay. So do we have Mr. Briggs now?
Okay, Judge, I'm now logged in on Michelle Hill's.
And I see ADA Hill, that's Mr. Briggs. If you'll just select the correct channel, the English channel, because I do not hear you. All right.
Okay, Judge, I'm on Ms. Hill's computer and
Okay.
the English channel. So
Are you good? Can you hear us?
yes.
Yes. Okay. All righty. So I think everyone is here now. All right. So let's go ahead and get started. Chewy, would you please call the case?
Yes, Judge. It's cause number 2021-0D0-2909, State of Texas versus Ivan Gavaldon. Announcement to council, please.
Here for the state, Curtis Cox, Scott Ferguson, Renee Flores.
And good morning, Your Honor. On behalf of Mr. Gabaldon, it's Denise Butterworth, Omar Carmona, and Felix Valenzuela, and we are ready.
And Mr. Gavaldon is appearing from the jail annex. He is also utilizing the assistance of a court interpreter today. Ma'am, would you state your name for the record? Thank you, Ms. Noyola. Just as a preliminary matter, again, we are proceeding on this hearing today remotely via Zoom per orders. All matters being heard today are being heard in accordance with all emergency orders regarding the COVID-19 state of emergency. In addition to that, we are streaming all matters live via YouTube for public viewing. I will just because we've had so many technical issues this morning with Zoom and being able to hear, please, for all who are participating in today's hearing, if you would please let us know if at some point you cannot hear us, so we can go back and either try and fix the connection or find a better way to have you all connect. In addition to that, the official record of all proceedings in this court are handled by our court reporter, Ms. Erica Wright. The YouTube feed is not to be recorded, and it is not the official record of any court proceeding in the 210th. So with that said, let's go ahead and get started. We were scheduled today for a motion hearing, and there have been several matters that have come up. From the last hearing, I believe I had requested that the state provide its decision with respect to the death penalty notice, which, thank you, Mr. Cox, we did receive ahead of the deadline. So we received the notice of the state's intent to seek the death penalty on November 22nd. But we, of course, as we were scheduled for trial this week, had set this hearing to address any other matters that are outstanding. I have received, in addition to the state's notice, defendant's motion to dismiss based on prosecutorial vindictiveness. And I did receive, that was filed November 23rd. I did receive the state's response to that motion this morning, and I've been reviewing it briefly as we've been waiting to get logged on live. I also have a motion for preservation of evidence from the defense filed on November 22nd. And I think there was one other, there are several other, I think, more administrative pleadings that are filed, but there was one inquiry, Mr. Cox, I think, regarding the appointment of the attorneys. I did see an email, which I had looked at when you initially filed that motion to confirm that Ms. Butterworth was in fact a first chair death penalty attorney. And so am I understanding that you all are good to go with, there's a couple of things here for my purposes that I want to make sure is clear. Number one is, yes, Ms. Butterworth is, she will be first chair appointed. The other thing I had noticed, Mr. Carmona, on the case that Mr. Lozano from your law firm is the actual appointed attorney for this case. I want to clear that up and make sure that the appointment is of Mr. Carmona for second chair.
Your Honor, I am on the second chair list, Your Honor, for a capital murder death case. And so I can file a change of designation. We have been in, obviously, as the court knows, Mr. Lozano and I are in the same law firm, and I have been handling this case. So I will file a change of designation.
Okay, beautiful. That clears that one up for me. Ferguson, were you back? Okay.
And Your Honor, the state's request was simply a request to inquire. Now,
Yes,
we were not objecting, and of course, we have we have no position on anything regarding the defendant's representation. We simply were requesting that that inquiry be made so that there won't be any allegations of ineffective assistance or anything like that. So
absolutely, we're dotting our I's, crossing our T's here. So it was a valid inquiry, and I had recalled before that, actually, that I think when we got the list, Ms. Butterworth a few months back had been updated. I remember the list getting updated there. And let me just ask, because I know we have Mr. Valenzuela here as well. I know we spoke briefly off the record. Mr. Carmona, Ms. Butterworth, were you all making a request for additional counsel?
Yes, Your Honor. We are asking that Mr. Valenzuela be appointed. Obviously, Mr. Valenzuela not only has experience with capital murder death cases, but he also has an expertise in appellate cases of this nature. So we believe that in order to protect our clients' due process rights, a co-counsel would also need to be appointed, Your Honor, of Mr. Valenzuela's caliber of his expertise, and we're asking the court to appoint him co-counsel.
And again, as I mentioned off the record, it's like you all were reading my mind, Mr. Valenzuela, you will be appointed to represent Mr. Gabaldon as well. So obviously, I've given just a quick highlight of some of the things that have come up. It is not meant to overlook that, but it has significantly changed may significantly change how things are going forward. And so, because I think the shorter, or the quicker motion that can be addressed now, I think, is the motion for preservation of evidence. Does the state have a position on that?
Your Honor, if anything needs to be in evidence regarding prior hearings, we have the record and we have the court's recollection of what happened. If the court needs to take judicial notice of anything such as facial expressions, I do not believe it is proper under the law to use the YouTube video as evidence in a case. It is not part of the record.
Okay. Ms. Butterworth, Mr. Carmona, who's gonna tell me a little bit about this one?
I will, Judge, and I'll be addressing all of the motions today.
Okay.
So we filed this, Judge, as quickly as possible after the flurry of events that took place and occurred last week. And we are requesting the court allow, and so we filed it as soon as possible for a recording to be made of the YouTube hearings that occurred last week. Very specifically, I think they both were important, but really it was the hearing that was held on November 16th of 2021. I know the court will remember that particular hearing, but it is the defendant's assertion that it was that hearing that a threat was made by the state of Texas against our client, violating every kind of due process right he's entitled to. And what I explained in the motion to preserve the evidence is that we are concerned that the record may not capture things like tone, facial expressions. It's the visual context, whether there's an increase in volume. And we do have the YouTube hearing. I know it's not the purpose of an official transcript, but I'd like to think it's akin of, it's evidence. It's evidence in this particular case. We're not asking that it be preserved for purposes of presenting to a jury trial down the road, but we do believe it is 1,000% relevant and pertinent to our motion that we've later filed, the motion to dismiss. And it would just be an additional piece of evidence that we would be entitled to attach or use or have as part of the record for our motion to dismiss going down the road for whatever appellate purpose that would happen. It's almost like we're asking to preserve it, to offer it for appellate purposes. And I go back, Judge, to just how important that particular hearing is. The crucial visual clues, the voice inflections, the volumes, we're gravely concerned will be lost in a transcript. And so we filed this motion as soon as possible so that the YouTube hearing would not be destroyed or taken down. Again, it's not for purposes to present to a jury, but it is for purposes that we believe an offense was committed during that particular hearing. We'd like it to be part of the record for whatever purposes an appellate court will review this particular situation. I truly am arguing on behalf of my client, the defendant, that this recording has evidentiary value. I can't imagine. I know that we're all new in the Zoom hearing era that the pandemic has brought, but I can't imagine that if something were to happen where one of us were to be live on Zoom or have these YouTube recordings and an offense comes, like I would be shot or killed, and it's evidence. It would have been recorded. And so for those purposes, Judge, we're asking that the court grant our motion to at least preserve it for appellate purposes, especially in the context of the decision that the court is going to need to make on our motion to dismiss.
Mm-hmm. Anything else, Mr. Ferguson?
Well, yes, Your Honor. I would argue that to do so would be in violation, of course, of the Supreme Court's emergency order. I mean, this was not envisioned at all in the order that they issued allowing Zoom hearings. And as a matter of fact, the statement that these are not to be recorded or used for any purpose, I think is completely applicable here. Thank you, Your Honor.
Okay, I don't see a filed response to that motion, Mr. Ferguson or Mr. Cox. Can the state provide the court with a written response on that?
We can, Your Honor.
Okay, if you will do that, please, before the end of this week, so I can look at that, anticipating we will have potentially another hearing on that. But I do want to see I understand the concern, Ms. Butterworth, but there is the issue. And as you all are both aware, I mean, this is, when I saw the motion, I understand where you're coming from it, but there are limits. There are limits, you know, and it's true. We are in this, you know, Zoom, YouTube world, and I understand your points. However, it is my understanding up until this point that there is not, you know, the YouTube video is there simply to comply with the open courts provisions. And literally, if that video, if I had deleted it the day of, it's gone. You know, it is not the official record. And I understand what you're saying. So I want to make sure, and I want to let you all know that, you know, it is, I am not deleting it in the interim, right? I have not, but it is not the official record. And so I'm not sure exactly, without a little more guidance, how we get to a point where it's usable, you know, usable down the road. So I need to hear a little bit more on that. So what I will tell you all is that for now, those recordings are on our YouTube channel. I am not deleting those. If at some point the parties, you know, I'm not sure I would have an issue even providing the recording to defense counsel and the state. I just don't know what you can use it for. You know, what is the purpose? It is not part of the official record, I don't think, but I want to hear that. I want to hear that. And I know what you're saying, Ms. Butterworth. So just nothing is changing on that. I want to see a response from the state, and then I'll give you a ruling. Okay, so before we go to the motion to dismiss, is there anything else outstanding you all want to address?
I will tell you, Judge, there is, the state had filed a motion to carry over that we're in agreement to, so that would be an easy one to take care of as far as one of the first filings.
Okay, that's one I have not printed. All right, let me just take a look at it. I'm sure it's just a standard motion. Yes. All filings under. Okay, and that is granted without objection. Okay, thank you. Thank you, Ms. Butterworth. Who's next? I mean, what's next? Anything before the motion to dismiss?
I think, Judge, there are, I don't know if the court is prepared to rule today on the motion to dismiss. So in an abundance of caution that we don't get a ruling, I'm looking at 3 additional motions. There was a motion for special veneer. There is a filed by the state. There's a motion filed by the state for the demand of individual voir dire. And I believe now we have clarified that the motion for housekeeping purposes, the other additional motion for the state filed as far as the compliance with the Code of Criminal Procedure 26.052, if the state would agree, has been addressed at this point. Is that correct? Would you agree?
Yes, the state will agree.
Okay. So then the motion for special veneer and the motion for individual voir dire might be the easier additional state motions that are on the table before we get to the motion to dismiss that was filed by the defense.
So my thought was to take those after the motion to dismiss.
Okay.
Okay, unless you all see a problem with that. So let's go with if I'm not hearing anything else, let's go for the motion to dismiss. Ms. Butterworth.
Thank you, Judge. So as soon as practical that we were able to file this, we did. We, after getting notice that the state filed the notice to seek the death penalty, which we believe was the straw that broke the camel's back, for lack of a better word, as far as the proof we needed. We filed this motion to dismiss based on prosecutorial vindictiveness. And I know that what I'd like to do before arguing the motion is I want to make sure that I am allowing our record to be super full and complete and clear. So for housekeeping purposes, Judge, we are asking that the court take judicial notice of the court's file on the original murder cause number of the 2021 0D00530. And we are also asking for the court to take judicial notice of the new indicted cause number, the 2021 0D02909. Again, for purposes of the record, we're going to be citing, and I believe for appellate purposes, we would like anyone reviewing this to have the filings that were made by both the defense and the state, and probably more importantly, the lack of filings under the old cause number to be part of the record. And so we're asking that be done before I begin trying to argue this motion.
And the court will take judicial notice of all filings of the entire court's file in the previous cause number 2021 0D00530 and in the current cause number 2021 0D02909.
Okay. So, Judge, what I'd like to do as far as arguing this particular motion, I want to make sure that the record reflects the position that the state of Texas was in the morning of November 16th, before we began that particular hearing. Because I think the timing of filings, the timing of arguments, the timing of everything that has occurred so far is fundamental to our motion to dismiss based on prosecutorial vindictiveness. And so before the beginning of the hearing, before it was called on November 16th, there had been a discovery order on file under the old murder cause number. That discovery order was filed on March 29th of 2021. And specifically, there were basically orders from you, Your Honor, as far as deadlines that you were requiring for us to abide by in order for us to proceed forward. And I know that the last hearing we had, I made it clear on the record that we had originally been set for jury trial in November, and that notice was given to us in June. Again, just kind of making sure the record is clean as far as how much time the state was afforded to be ready. And then at a hearing in October, I believe it was October 5th, if I'm not mistaken, that changed and the jury trial was then moved to December 2nd for administrative purposes. But going back to the discovery order that was on file that would have applied to the December, and does, we would maintain, continue to apply to the December 2nd hearing. It required, or you required, Your Honor, that the state give the defendant, and this is every single argument we have is on behalf of our client, Mr. Gabaldon, that the state and the defense be required to give each other written notice of experts 30 days before December 2nd. I want the record to reflect that there was no filing, no written filing made by the state of Texas, giving the defendant any notice of experts for the December 2nd jury trial until it was a late filing and it was amended. But for sure, the record will reflect that there had been no filing 30 days before the December 2nd hearing. The state was also supposed to give written notice 14 days of extraneous offenses. And that, of course, is to include the county where the alleged offense occurred and the name of the victim. There had been no filing of a notice of extraneous 14 days before the December 2nd hearing. There eventually was a filing that was made by the state of Texas, giving us notice of extraneous, and I'll talk about that in a second. But it was absolutely and is and continues to be untimely for purposes of the December 2nd hearing. Also, before the November 16th hearing, there had been no subpoenas issued by the state of Texas for any witness they intended to call. And then, of course,
Ms. Butterworth, I just want to double check because I'm hearing some intermittent audio. Erica, were you able to?
Yes, it's still going, but she's going to cut off soon, I think.
Yeah.
She's going slow enough though.
Yeah, thank you. We'll just, I'll remind you if we miss any more. It was cutting out a bit, Ms. Butterworth. Thank you.
Okay. And then, of course, lastly, we did have the one state filed notice of the translation made of my client's statement, and that had been litigated, or I guess it was litigated on November 16th, but so before November 16th, that was the filing that had been made by the state of Texas in preparation for the December 2nd jury trial, but it also was untimely pursuant to the Texas Rules of Evidence 1009, and then ultimately that was conceded. So when we begin...
I'm sorry, I'm going to have to pause right here just for a second. Ms. Butterworth, because I'm afraid we're going to lose too much and it might be too difficult for the court reporter to take down what you're saying. If we could pause for just a second, if you are able, do you have another device that you could call in on and mute your computer, leave the video on, so that we have a better connection?
I do, Judge.
Go ahead, take the time. Take the time and see if you can log on.
And then if somebody could send me in the chat the phone number that I would dial in on.
I think it's queuing up.
I will, Judge.
Thank you. Yeah, there's always these days, for whatever reason, we have a lot of technical issues. This appears to be one of those days.
Mr. Pantoja, do you have the meeting ID handy as well, so I don't have to get out of my screen?
Yeah, I'll send it to you right now.
Thank you.
Okay. It was just.
I've got it. Thank you.
And for anyone who, if you start noticing you're having issues, or if you tell me then that, or if I'm able to hear it, just know that the meeting ID, I think there's a number there as well, is available so that we don't have to stop, since this seems to be happening even from different locations. I'm going to assume that's Miss Butterworth, and I just let her in.
Okay, let me meet.
Yeah. Okay, Ms. Butterworth, can you hear us? And I think you'll have to select the English channel from your phone so I can hear you.
Okay, that one's got me stumped, Judge. How do I select English from my phone?
Erica's saying something.
I'm
I
saying
think-
that's Miss Noyola. She's right there. The interpreter.
Ms. Butterworth, real quick, this is Sandra. If you go to the bottom right of your phone, there's 3 little
What?
dots.
What was that, Miss Noyola? Okay, so maybe, okay, that's not gonna work. All right, Ms. Butterworth, do you have another device by any chance? That is not your phone?
Should I hang up on this call now, Judge?
I think so, because I'm not gonna be able to hear you.
Okay, can you hear me now?
Yeah, let's just proceed like this. And hopefully it won't.
What Murphy's Law, I've been doing Zooms from my office. All of the last discovery hearings, this is where I've been with no problems.
Mhm,
Your volume goes up and down. It's like a wave.
mhm.
And if anything else, I guess you would need to log in Zoom on the phone. But I mean, like, we could just keep going and see.
Okay, let's just try, keep going. Sorry, Miss Butterworth,
It's okay.
let's keep going.
Okay.
Okay, we were at the rules of evidence. It
Well,
was
I don't know where I was, so
oh, well.
let me start over.
Before November 16th, it says.
Okay,
was a
it's
filing.
under my umbrella of where the state of Texas was before the November 16th hearing. So there had been an untimely notice of translation that was filed. And that's where we were when the proceeding began on November 16th. So during that hearing, I want to make sure the court remembers. Oh, I know there was one additional thing I would like to offer. I have requested, Judge, and we're all behind the ball because of how quickly this all happened and how late in the game all of these decisions were made as far as the state of Texas. So I have requested from Ms. Wright actual official transcripts of the hearings for both of our October discovery hearings that we had, and also the November hearings, the one on the 16th and the one on the 19th. And so what I'd like to do, they're not ready, obviously, again, because all of this is such short notice. But when they become ready, I would also like to offer the transcripts of all 4 of those hearings that we had on discovery issues in this particular case, when they're ready. So when we begin the November 16th hearing, I know the court will remember, but we basically begin the hearing by a question from Your Honor asking if we've been able to resolve anything. And then we all smile awkwardly and let the court know that we have not resolved anything. In fact, we have never been in negotiations on this particular case. Then there was a question from the court on whether there was a rec for this particular case. And at that point, Mr. Curtis responds, beginning this November 16th hearing, that he says, because the defense has asserted a general denial all along, which I respect, and indicated they wanted a trial as quickly as possible, that is his reason as to why there is no recommendation. The record was clear. We've never participated in any kind of negotiations, and that he was aware that from the get-go, from the very beginning of the inception of this lawsuit, we were asking to go to trial. But then right after that comment, beginning of this hearing, Mr. Curtis Cox then adds, but I would be happy to negotiate with them if they want to. but obviously it's their client's right to demand we prove it. So we begin the November 16th hearing where Mr. Cox is telling the court, the defense, I am willing to negotiate on the indicted murder cause number. I'd be happy to negotiate. So I want to make sure the record is clear on that, because that is as important as probably the next thing that happened at that hearing, which is that the state of Texas on its own offered our client a PR bond. It shows the state of mind and where the state is on this particular case. Instead of arguing from the get-go, this is so heinous, this is so wrong, this is so awful what the defendant did, and this is clearly a death penalty case and a capital murder. That is not how that hearing began. It began by Mr. Cox saying he would be happy to negotiate with the defense on some sort of plea on the then indicted murder case. And then, of course, that quickly follows by the state of Texas conceding on November 16th that they are not ready. There was no discussion beginning that hearing by Mr. Cox saying, like, stop, stop, stop. We're re-indicting. We're re-indicting. We've got the wrong charge. This wasn't handled correctly. Instead, the hearing begins by offering to negotiate on the then indicted murder case and then asking for the court to consider a PR bond after a full concession that the state was not ready for trial on December 2nd. And then we have a hearing and it becomes very contentious. And we are arguing all day long during that hearing on November 16th that we are asking to go to trial. And we go through point by point of how this played out and who is at fault for the delay and why the state isn't ready. And again, the timing is everything for you to consider, Judge, because at the end of the day, this motion to dismiss is based on your factual findings, your credibility findings of the events, how they played out, and what is going on as far as how this case progresses. It is not till the end of that hearing that Mr. Curtis Cox then tells the court, oh, and by the way, we're possibly going to re-indict. And that's when we believe, according to our motion to dismiss, that it was proof positive by Mr. Cox's response that that assertion of seeking a re-indictment was in order to delay. And that's why I'm trying to make sure I spell out exactly how late in the game this is happening and how much the state, they even conceded, was not ready and would not be ready for that December 2nd trial. They would not have and continue to still not have any extraneous offenses to present to a jury in this particular case. No expert witnesses and no statement by my client. I will tell you, Judge, I know I put it in the motion, but I want to make sure I re-argue it here on the record. I hope the court took notice, and if not, the transcript will also show it, that there were multiple times that Mr. Cox replied as far as that late notice of the filing of translation. And I think it's very important for the court to look at exactly what his response was. In the November 16th hearing, when we argued that that translation filing was untimely, his response then was, for the current trial date, it is untimely, but then states, but if for some reason this trial date should get moved, well, then it's not untimely. And that was said again in the November 19th hearing, when for whatever reason we spoke again about the untimely statement of our client. He then reiterates on November 15th and says, again, when we're talking about the translation, he's being untimely. He says, for this trial setting, that is correct. It was at the end of the hearing on November 16th, Judge, and I know that I've gone through this and I'm going to reiterate one more time, and it's one of the reasons that we've asked to preserve that evidence, but thankfully you were present for it, and you're the one that ultimately decides these factual issues, the credibility issues. But it was at the end of that hearing when we were talking about the state's motion for continuance, that we believe is absolutely proof positive of our motion to dismiss based on prosecutorial vindictiveness. And again, I've said it, so I'll say it one more time and I'll move on. It was at that hearing, Judge, that November 16th hearing, that at the very end of the hearing, I believe the court was even asking, is there anything else before we conclude the hearing? That is when the state comes forward and says they're going to re-indict. And it really is in response to Mr. Carmona's response where the threat occurs. Because Mr. Carmona says, that's fine, re-indict, whatever, re-indict. We're ready, and we will waive our procedural 10 days notice, and we want to go forward on December 2nd. And that is where we believe the first prong would be met on our burden to show the motion for prosecutorial vindictiveness, because that is when Mr. Curtis Cox then threatened and said, I do not believe you can waive those 10 days while we make this decision. So I'm going to repeat that, because what he's saying is, no, sir, defense, we'll get our continuance. I do not think you can waive those 10 days while we consider whether to seek the death. However, I will seek the death penalty if that is what becomes necessary. I will move on, Judge, because I know that I argued that on November 19th, but I want to make sure that that evidence, which is why we filed the motion to preserve it, because we are contending that evidence is proof positive of the burden the defendant would have to show that the state of Texas re-indicted and chose to seek the death penalty for purposes of delay. It was a flat out threat that was made during the hearing. And I don't know if there's any other better evidence than the fact that the threat was made. The other prong that the court could also find as far as granting our motion to dismiss. So there's two ways under the law that the defense could show this and prove this, and more importantly, for the court to find it. The one is— Hold
on. Erica, are you?
Yeah,
speaking?
she's going in and out, but yeah, the last sentence, I proved something. That's the one I didn't get. What you were just saying.
You could just start that again.
Sure.
It was going okay for a little bit, Miss Butterworth, and it started to get choppy again.
Okay.
Just start there with the second prong.
I'll proceed. I just, again, so for to kind of summarize where I'm going in the argument, when we filed the motion to dismiss, we believe that the law allows the defendant to prove the prosecutorial vindictiveness two ways. The first way is showing direct evidence that the prosecutor's charging decision is an unjustifiable penalty resulting from the defendant exerting his rights, that he is and particular in this particular case, his right to speedy trial, his right to go to trial on December 2nd. We believe that that threat is proof positive of the second prong that we would be required to prove. But we also are able to prove it under the first prong that the law has, which is for the court to find that in all of the totality of circumstances, for the court to look at every single hearing that has occurred in this particular case, that when you combine it all and you look at the timing of some of these arguments, the background of what was going on, there were no filings, there was no ability for the state to go forward on the December 2nd hearing, that you can find that all of that together, when you consider it, poses a realistic likelihood to raise a presumption of prosecutorial vindictiveness. And that is why I began that motion under Roman numeral 1, making sure that we have a clean record of exactly what was going on in this case. And I went through procedurally every single date that I thought was important to show just how behind the ball the state was when they chose to go and re-indict this case on November 17th. One of the things that I wanted to mention is the filing that the state had that we heard on November 16th. That was a filing that the state made, and I believe that the court can find reasonably that this particular finding was an attempt to delay the December 2nd filing, and that was that motion to object to the jurors wearing masks. When that motion was being argued, I hope the court will remember on November 16th, Mr. Cox was saying that he had copious amounts of case law to support that argument. And basically told the court, this will be reversible error if we go forward, Judge, on December 2nd, reversible error. And thank goodness, the court asked, that's fine, Mr. Cox, that's what you're arguing, but could you back that up with some case law? Where's the case law in this motion? Where is the law that you're arguing this? And of course, ultimately, he wasn't able to produce it. But if you look at the motion that was filed and think about the repercussions of it, I believe that it again speaks volumes to this totality of circumstances of what's going on November 16th. And what I am arguing is it shows the state's desperation to get that continuance because they know they are not complying with the discovery order and they're not ready for trial. And so they argue that nobody can go forward picking juries in the state of Texas while jurors are protecting themselves wearing masks. And what they did was, if you break down and you analyze it, they compromised and jeopardized every other single pending prosecution coming out of that office because they were so desperate to get this continuance. Because they're arguing nobody can go forward. And that DA's office has, and I've argued it in the motion, so many critical cases pending to go to trial with some really bad defendants and some really egregious facts with victims who are waiting for their day to go to court. Everybody waiting for justice. And the DA's office laid that card, jeopardizing every single one of those cases that they're entrusted to be taking care of. And again, I could be wrong, but I also think it's super important for the court to note that they had never filed this objection before, as far as I am aware, on any jury trial proceeding. And not only that, they have announced ready on jury trial proceedings during the pandemic and have gone forward on those cases to a verdict by jurors. And so they were willing to compromise all of the litigation that has already occurred, the hard work that was done by their office on whatever verdicts they received in a guilty verdict.
It's getting a little crazy.
Yeah, it's getting bad, Miss Butterworth. They were willing to jeopardize every verdict was, I think, the last I heard.
Okay. I'll start over. They were willing to jeopardize every verdict they had already obtained, and then every case that has been pending. By making this argument, every criminal defense attorney practicing in this town could then turn around and use that argument against the state while they're trying to get continuances on theirs. Again, if this isn't spelled out, it could be lost. But that is the level of desperation that the state was under on November 16th when we proceeded in that hearing. I believe, Judge, the best piece of evidence, for the court to agree to grant this defendant's motion for vindictiveness, to dismiss it, was the PR bond that was offered in that November 16th hearing. I don't remember right now how the defense has tried to argue that away, but you can't. On one side of their mouth, they're saying everything we've done is in good faith because this was always a heinous case.
Sorry,
And
everything we've done was always, I didn't get that.
everything, sure, everything we've done so far is because this is such a heinous case and this defendant is so awful.
No,
But
Judge, I'm sorry.
I know this has been, I was hoping we'd get back on a better stretch. I'm going to quickly take a break, but not off of YouTube because I don't want to lose the YouTube feed. Miss Butterworth, I hesitate to do this, but I'm going to ask you to log off and log back in, and we'll just get you started again. Hopefully it seems to be your connection, because sometimes the video does also slow down. So let's have you log off, come right back in, and we'll just wait for you to come back.
I will, Judge. And then if that doesn't work, I'll try to move to a different office. I have no words. I've never had this problem in months of practicing here. Let me log off and I'll try to come right back on.
Thank you. Thank you, Ms. Butterworth. Would you just, and we can just do this off the record, maybe just say a few things that make sure we have a good audio, and remember to select the interpreter function English.
Okay, so I selected the English. I am now continuing to speak.
Okay,
I'm trying to speak as slowly as possible.
it seems better. The video looks a little funny, but it seems better. So I think we're try it that way. Okay, so we are back on the record in cause number 2021-0D02909. Ms. Butterworth, you may continue.
Thank you, Judge. Miss Wright, can you tell me where I was?
Okay. On one side of their mouth, they're saying everything we've done. Yeah. Then you started saying heinous, and then I had to stop. Yeah.
I got it. All right. So I guess the point we're trying to make is it appears from the state's position that they've been arguing as far as their reasoning to re-indict is because it was clear it was a mistake made by their office. And then they go through the reasons, but it's just because this is such a heinous offense. It's clearly capital murder. He's so dangerous. It's so awful. This is why we're needing to do what we're doing. And that is their response. It even appears to be their response to our motion to dismiss. And so that PR bond is critical. It is critical. I believe it supports the court's ruling in our favor, that it gets us over that hump, that there is a delay that is being attempted by the state. That is why they threatened to do it. It is why they did it. And there is no way that they can continue to argue after asking that our client be released on a full PR bond. That is what allows the court to find that there is prosecutorial vindictiveness. It flies in the face of logic. It flies in the face of any kind of reason and common sense. And the statement was made by Mr. Cox at the very beginning of that motion for continuance. It was made then because it was a desperate attempt to get the case delayed. And that is exactly what continues to keep happening here in this case. Judge, I think that the response, and I quickly read it, we were given a copy this morning, and I am gleaning that the response by the state based on the additional motion that we had heard when the state filed another amended motion for continuance, was that Mr. Cox is saying, we're not ready and it's my office's fault. So I want to make sure that we really break down that reasoning. I can tell you that there will not be an argument ever that can be had by the state that it is my client's fault. And that is critical to this motion that we have filed. It is not Mr. Gabadones. He sits there and has been sitting there in his cell waiting for trial. This is certainly not his fault. It is the fault as a whole of the DA's office. But the argument that the DA's office is making is that they should get this reset button because Mr. Cox came into this late. That's their argument, but that's not how the law works. And they don't get that reset button. They are the state of Texas, and they are supposed to be ready for murder trials. I know that Mr. Carmona had pointed out all the different lawyers, but I want to make sure that, again, that record is clear that just because Mr. Cox gets into it, they don't get this default time that they're asking for. It doesn't work like that. So when the case was indicted, and the court will remember, and maybe even the court can correct me if I'm wrong, as far as the lineup of prosecutors you have had in your court starting in 2021, I know that Ms. Ashley Martinez was the original prosecutor assigned to the court. I honestly don't know if she had been already transferred out when this case was first indicted. But I know that she was in the court at the beginning, and then at some point in time, I don't know if it was before it was indicted or very maybe recently thereafter, the DA's office made a decision to rotate lawyers. And again, I can only assume, I am not a presiding judge, but I can only presume that that's just a frustrating fact or reality that judges are dealing with, that lawyers, prosecutors in these offices are getting rotated in these courts. Because the reality, again, as a former prosecutor of 20 years, so I'm very familiar with how this works as well as the court is, that brand new prosecutor coming into the court has to start over by default. So these hearings are called or these cases come up, and the brand new prosecutor that just got rotated in has to tell the court, it is unfeasible for me to be ready on all these cases that are pending in this court. I've got to catch up. I've got to figure out what's going on with these cases. I've got to read them. I've got to know them. And so by default, that continues to be a delay that is inherently built in by decisions to rotate these prosecutors that has been happening. So Ms. Martinez was rotated out. Teresa Garcia, if my recollection is correct, comes into the 210th and becomes the new prosecutor of the 210th. She was a new hire under the new administration. That was a decision to hire her made by Ms. Rosales, the new DA that took office in 2021. And she was the prosecutor in this court for a while, kind of catching up on the docket and what these cases were about. And then she resigned. And then I believe, as far as a frontline lawyer, Rolando Morales was the next lawyer to be assigned to this court. And I believe he stayed, again, hired by the new administration, and he stayed less than a week before he resigned. And then in there, Miss Lenzui Vegada, again, who was a hire by the new administration, a hire into a supervisor position. And I say that because Mr. Cox on November 16th wanted to say this is all her fault. It was their hire. It was Ms. Rosales's hire to put her in a supervisor position. And again, it's not fair to my client that this is occurring while he sits in jail. But Ms. Vergara has the case for a while, and she also has resigned. She was hired by the new administration and resigned under the new administration as well. I believe Renee Flores then became a supervisor at some point. I don't have the timeline. And I think he is, unless he's not, I think he is on this Zoom hearing. So he is the current supervisor of this particular court as far as assignments on behalf of the DA's office. And then there was Brian Herrera, who I guess then was eventually the replacement for Rolando Morales. And Brian Herrera handled this case. Obviously, the record will reflect, began the heavy duty lifting of having to answer on discovery issues why, as far as mid-October, we still didn't have a statement from our client, and it was being ordered from the police department to come into the DA's office to then be, I guess, made a copy for us, to be copied for us. And then Mr. Herrera has been transferred out of this court, and there's a new rotation now. I believe it was going to be Mr. Josh Avila, that the court is very well aware. He was her former prosecutor, and he just resigned and put in his 2 weeks notice. The reason why I'm spelling out this timeline is because of the argument that the state of Texas should get a reset once one of the attorneys, Mr. Cox, eventually gets brought into all that has been happening on this particular case. But the law does not require the reset. They don't get that reset because it's not the fault of our client. It is whatever is happening right now at the DA's office. And I believe the court made that clear when the court denied the motion for continuance. Our laws are designed to protect individuals that have been charged by the state of Texas. And this last recitation of either the rotation of lawyers or the turnover of lawyers in this administration is not the fault of Mr. Gabaldon, who sits there and continues to be waiting for his jury trial. They don't get a reset. And I believe that is what this boils down to, is we have the hearing on the 16th, and I want to get into a couple more points on that before I move on to what happens after the 16th. During the hearing on the 16th, we talked to the court about some conversations that were had by Mr. Carmona and Mr. Cox, where, and I think even Mr. Cox conceded it, that he was not entirely finished reviewing the case. So I'm going to repeat that again. On November 16th, there were conversations in the hearing, and the transcript will reflect them. And again, we're going to ask that those transcripts be part of this record. But it is clear that on Tuesday, November 16th, Mr. Cox has not fully gone through the case. And even is shown on the day of that hearing how unfamiliar he is with the case, because he says that they have two witnesses that they filed the motion for continuance, saying they need to have them. They're looking for those witnesses, even though no subpoena had been filed. But he isn't even aware, and it's shown on the hearing of the 16th, that he's not even aware that those two witnesses gave written statements to the El Paso Police Department. Again, just kind of exposing how unfamiliar and behind he is on reviewing this case. And then he says something about, and Judge, you know, we need a continuance because there's a female that says someone other than the defendant killed the victim. And I'm going to repeat that. And of course, it'll be in the transcript of November 16th. But Mr. Cox argues, and I also need to get a hold of a female. There's a female out there that says someone other than the defendant killed the victim. I will tell you, I've been through this discovery multiple times in preparation for the December 2nd hearing. There is nothing in the discovery that was provided to us about any of this. But what's more important to note is that statement was made on the record at a hearing on November 16th. I need to get a hold of her. I need to figure out what this is. And then on November 17th, the state of Texas takes this case, presents it to a grand jury, and secures an indictment for capital murder against our client. Less than 24 hours of showing how much work they still needed to do after exposing how still unprepared they were for that jury trial setting. The following day, they get an indictment for capital murder. Then they file an amended motion for continuance, continuing to beg for more time, that they're not ready for the December 2nd hearing. And now it's capital murder. And then there's a request made, I believe it was by Mr. Ferguson, with an exact amount of time. We would like 30 more days, i.e. just get us through and past this December 2nd jury trial setting. And the request is denied. And then at some point, we get notice that the state of Texas filed its notice to seek death. And the two things I want to make sure I point out as far as that is concerned is we are still bound by the discovery order that is in effect for this December 2nd jury trial setting. And so a decision was made to seek death, even though they are out on any notice of extraneous. There was one filed, it was untimely. And in that particular case, the notice of extraneous that was filed gives us, again, not timely, gives us notice that our client, there were two things listed on that notice of extraneous that I want the court to be aware of. I'm hoping the court saw that filing, but I want the record and the court to be aware of this weighty decision to seek death, to tell the community, to tell the court, to tell my client, more importantly, you need to die. And we're seeking to try to make that happen. Because life without parole isn't enough to secure the safety of our community. So we threatened it unilaterally in the middle of a hearing, and then we actually did it. We filed notice to seek death. And on the late extraneous offense that I will argue, Judge, all day long, I don't care how long it takes for us to go through this, kick the can down the road, and now have to go through individual voir dire that the court knows will take months to go through in order to select this jury, and the state knows it as well. We will continue to argue. You want to play this game, you want to continue it, you want to pretend that this is a death penalty type case. We will continue to assert that December 2nd was the deadline for these filings, and they are late and they are out. But when they did file it untimely, there is a burglary that is listed, and in the discovery provided to us, our client is being accused of going into a building and stealing a $3 bag of Dorito chips. And the second thing listed on the notice of extraneous was our client received some sort of punishment in the jail, a disciplinary hearing for not obeying orders. And as of this date, we have not received any kind of discovery regarding that second allegation, nor, and this is important too, which is why we're asking the court to take judicial notice of the court's file, nor are there any witnesses for either one of these extraneous offenses listed even in their updated notice of witness list. Not a single witness out of Doña Ana County to prove up the theft of Dorito chips, and not a single sheriff's deputy to prove up this disciplinary action against our client. Why am I pointing that out? Giving them a heads up, hey, you probably want to redo the sloppy work that's being done, is because it shows the lack of intent. It shows the lack of preparation. It shows that these are not extraneous offenses that would be considered in a death penalty phase, that they would be out anyway because they were untimely. But more importantly, it shows the court what the state has when they, with a straight face, tell this court, this is a death penalty case. And when this court looks at Mr. Gavadon, that's what they have, Judge. And then, of course, the $1 million question on the table that we have been arguing from the inception of this is our client is not guilty based on self-defense. We've also argued, we've also ordered a copy of the bond hearing that occurred, where that was the argument during the bond hearing. And I believe it was Mr. Briggs that handled the bond hearing, where there is absolutely no allegation that this was a heinous murder in the course of intentionally killing this man to steal his truck. Instead, it was, this may not be self-defense because the defendant was able to take the knife out of the victim's hands. And therefore, the argument was he was no longer entitled to use self-defense. That bond hearing that we're waiting for, the transcript that will also supplement, is also important for the court to consider. And now Mr. Cox wants to come back and say, I don't know, I'll let him say whatever he's going to say. I will tell you, Judge, I believe this is so obvious to every single person that has watched how this has played out, and I'm hoping to the court as well. And what I would ask for you to do, Judge, when you make this decision on whether to grant our motion to dismiss based on prosecutorial vindictiveness, and what we're really arguing is that this ridiculous attempt to delay, I'm asking for the court to remember where you were and what you were doing when you found out that they had actually filed that notice to seek death, and what it did to your tummy, because that is your answer. That is your answer. I was left I was left shaking when they made good on this threat just to get past this December 2nd hearing. Shaking. I haven't slept. I know Mr. Carmona hasn't either. It's wrong. It's wrong. And you know it, and we know it. And thank God the law allows you to rectify it. I have never probably been more frightened of the power that the state of Texas has. It is truly frightening what they have done and that they're able to do. But the reassurance to my client, Mr. Gabaldon, as he sits there, is that they can be stopped by you, Judge. And that is exactly what we're asking for you to do. Thank you.
And on behalf of the state, Mr. Ferguson or Mr. Cox.
Your Honor, I'll begin.
Yes, sir.
And the way that I want to start my response is by reminding the court and the other participants in this hearing of what Texas law actually requires in regard to imposition of a death penalty, and that is that the jury answers two questions. And as Ms. Butterworth well knows, I guess the way to put it is this: a lot of argument has been put into the idea that we reserve the death penalty in Texas for people who are so, as she herself, I believe, said at a previous hearing, we reserve it only for people who are so dangerous there is no other solution to their existence. But when you look at the first question a death penalty jury has to actually answer, it is simply this: do you find from the evidence beyond a reasonable doubt that there is a possibility that the defendant will commit criminal acts of violence that will constitute a continuing threat to society? And I would submit to the court that in my 15 years as a prosecutor, that question could be answered yes to probably a majority of the people I have prosecuted. Okay. We are not asking our juries to make a statement about, gosh, they are so dangerous, there is no other solution. We're simply asking, do you think they're going to commit criminal acts of violence in the future? Now, I have been circumspect in all of the hearings up to this point, more so probably than I would have been before the pandemic, because all these hearings are being broadcast to YouTube and are de facto much more visible. It used to be that you had to come to court to see what was going on. Now you just tune into YouTube from wherever you are and you see what goes on. And so I have avoided discussing the facts of this case, but because the motivations of the state for seeking the death penalty in this case have been called into question, I think it's now necessary to go into some greater detail. And I want to start with why.
Mr.
Yes,
Cox, if I could just stop you right there briefly, because I did receive your response this morning and reviewed it briefly. I don't know that I've gotten into such detail, but it sounds like something that I did read in your motion.
Yes.
Just want to remind the parties that the court, although we have been set up during the course of the pandemic for this procedure, allowing for this procedure for hearings to be conducted remotely, it has been some time that have, and I believe it's in all of our email notices regarding Zoom hearings, that the court is accommodating in-person hearing requests. And so if parties were not aware of that beforehand, I just want to make that quick reminder, because I have not yet on this case received any requests for in-person hearings. But I just want to put that out there, because we do accommodate those requests, although I do believe every one of the hearings that we have had on Mr. Gabaldon's case have been done via Zoom. So you may proceed, Mr. Cox.
Thank you, Your Honor. Fundamentally, this is a case in which the evidence shows that the victim was targeted for robbery and murder due to his sexual orientation, specifically because he was an elderly gay man. The evidence shows that the defendant knew the victim was a gay man and that he premeditated a robbery of the victim based on his knowledge that the victim could be lured into a secluded location because of his sexual orientation. Specifically, the state has access to witnesses and evidence showing that the defendant felt he needed money to support his family in Juarez, that he met with an associate to discuss that need for money, and that he then sought out the victim. The evidence further shows that in the course of committing that premeditated robbery, the defendant stabbed the victim approximately 20 times while the victim was on his knees. And the evidence also shows that after the murder was completed, the defendant took the victim's truck and sold it for a total of $200 in cash. Texas law allows, and in fact, you can strike jurors from a death penalty jury if they are unable to consider answering question one, yes, solely from the facts of the offense of which the defendant has been found guilty. The idea that there has to be an extensive notice of extraneous offenses, an extensive prior history, is not borne out by Texas law. The facts of the offense are enough. This case is the functional equivalent of a hate crime, and the state's decision regarding re-indictment and whether to seek the death penalty all flow from that understanding of the evidence.
So, Mr. Cox, I need to just briefly stop you there. And if you need to continue, because I know this is something that I have read in the written motion.
Yes.
You are reciting, I guess, additional information that went into a decision that not only to seek a re-indictment, but then subsequently to seek the death penalty in this case. My question, and I'll let you proceed, but this is what I'm looking at, is what changed? What changed, for example, between a November 5th setting, any previous hearing, that we get to November 16th, and then we get our re-indictment, and we get to a decision, a pending decision. What changed that was not available? What was different? What was different between, let's say, our original November 5th trial setting that we'll get to December 2nd reset? What changed that made the state, for example, you're reciting these facts. I am only going to take your word that, why wasn't this available before? Why the timing of it, and the way in which the state brought this to our attention is a concern,
What changed was my involvement in this case, Your Honor. I can't vouch for why the people who handled this before me did not see in this case the things that were glaringly obvious to me. Apparently, those who handled the case in indictment and previous to my becoming involved in it overlooked the evidence that indicated that this was an intentional killing in the course of a robbery because they indicted it as murder, not capital murder. But I was not involved in those decisions, and I cannot speak for what led to those. And the people who handled this in the courtroom, which would be the chief of the trial division, the chief assigned to the court, because of it is a murder case, in the office it is now being administered. The chief of the trial division and the chief assigned to the court handled the murder cases.
And so, and that I don't mean to necessarily highlight that. I know you also put that in your response, just the previous handling. But I guess at the point when you become involved, Ms. Butterworth has brought out, and it's in the record. I think it's in their motion to dismiss as well. For example, on the individual the female outstanding witness, when I asked about that individual and if there was an update or if there was a statement, it was clear to the court that you, now having handled the case, you weren't aware there was a written statement. And so what has changed? Was there some, further evaluation? Was that statement disregarded? I'm not really understanding.
No.
Mm-hmm.
Well, what there is in regard to that, there is one reference in the offense report by a police officer
Mm-hmm.
recounting that this female witness had supposedly told someone that someone else did it. That is not borne out by the rest of the case file. There is a phone call by the ex-boyfriend of Miss Priscilla Valenzuela saying that, another person put the defendant up to this killing. That is a 911 call that is recorded and I believe is available on the portal. That is a witness who is operating off of secondhand information. Ms. Valenzuela's statement, and we are now in contact with her, and she has been subpoenaed. Ms. Valenzuela, and she's cooperative. Ms. Valenzuela's statement is actually that she was the ex-girlfriend of a man named Louis Henry Bueno, that she was at Bueno's apartment on the night of the murder because it was his birthday. She brought spaghetti. She was there when a young man she knew as Chavalon showed up and spoke with Mr. Bueno about needing money. And then she saw him leave and then return an hour later and trade the keys to a vehicle, which was later matched to the defendant's truck, to Mr. Bueno for $200.
That statement has been part of the discovery from the get-go of this particular case, Judge. I want to make sure that the court is not confused, that that's brand new, hot off the press information.
No.
I'm not denying that.
I understand. And I understand, Mr. Cox. I understand what you're telling me in terms of, basically when you come in. But I guess my question is, because I'm seeing this as two decisions that I think are at issue. One is the decision to re-indict, and then the other decision being that to seek the death penalty. I am trying to understand how we got, first of all, from a murder as originally indicted to one then being in the course of committing a robbery, making it the capital murder. How did that change when there doesn't appear. I mean, if it appears, it sounds to me, and correct me if I'm wrong, that the evidence that you had in your case was the same from the time we have a bond hearing, and I actually don't believe that was in this court, it might have been in the jail magistrate, to the point where we get to a reindictment.
Oh. How it changes, as I say, the people who initially indicted this case saw it one way. And then I saw it a different way. And that is not uncommon in this office. We reindict cases all the time. The timing of the decision on my part to reindict hinges on when I became involved in the case, which was very late.
Mm-hmm.
I saw as soon as I read the affidavit that I thought this case should be reindicted, but I've been a prosecutor for 15 years, and I also know that sometimes the affidavit doesn't reflect the totality of what's in the court file. And so it was necessary to review the 460 pages of the offense report in this case, solely to make sure that what was alleged in the new indictment was going to be supported by the direct weight of the evidence. And that did take some time. But the intention was there from the beginning. The execution of the intention was delayed until I had had time to satisfy myself that something had not been misrepresented in the affidavit.
And Judge, your question on the table is precisely why the defense subpoenaed Mr. John Briggs, who was the initial attorney that worked up this case, and why we subpoenaed the detective that handled the case by EPPD. And really we can call them or we don't have to. That was essentially exactly what we were going to prove. And I think that I can even just offer it, and Mr. Cox would agree that it is correct. I was calling the detective to make sure that the record was clear, that there wasn't this additional piece of evidence that came forward late in the game, or a witness that was discovered. And that was my purpose of calling that detective. I was also going to make sure that the record reflected by that detective's testimony that when EPPD handled the case and they personally spoke to my client and personally interviewed all the witnesses, their initial arrest warrant is for the offense of murder, not intentionally killing in order to steal the man's truck. And I'm assuming Mr. Cox would agree with that, and maybe there's no need to call that detective, that there was not something new that occurred in the investigation done by law enforcement. And then, of course, I was going to call him to testify that they had not ever been pretrialed by the state of Texas, that nobody from the DA's office in preparation for the December 2nd trial was talking to them. The reason I was going to call Mr. Briggs, and I think Mr. Cox would also just agree to this, is that he was the initial prosecutor that handled this case. Honestly, we were going to go through Mr. Briggs's resume, but the court knows who John Briggs is. He is a very experienced trial attorney. He is the lead attorney that is handling the Walmart case right now. He is the supervisor that handles all of the homicides. And I was going to ask Mr. Briggs, after you looked at the case with your experience, when you don't have a December 2nd trial date that you're late on, when you looked at it in all of your experience in trying to a jury to a verdict of death penalty cases, he believed and indicted that this was a murder case. I believe that's important. Based on his reputation in the community, based on his experience as a trial attorney, he did not see this as a capital murder, and no evidence has changed when Mr. Cox looks at it. He's their lead Walmart lawyer. And I was also going to, and Mr. Cox can hopefully agree to this as well, point out to the court that when this decision was made, do we seek a reindictment on a capital murder? Mr. Briggs was never contacted. I'm going to repeat that. Mr. Briggs was not contacted in this decision. Not one conversation had by Mr. Cox to Mr. Briggs. Hey, why did you indict murder? Why didn't you indict capital murder? Let's talk about this as an office together. He wasn't consulted in that decision to reindict, and he certainly wasn't consulted in the decision to seek the death penalty.
Okay, let me stop right there because I think we're going to get out of order here. I do know that we had the subpoenas issued and there are motions to quash at least with respect to John Briggs, and I believe there is also one for Brian Herrera. When you were referencing the law enforcement witness, is that Juan Dries Reyes?
That is correct.
Okay, so before we step over there, let Mr. Cox continue on his response, and then we'll go to potential matters with respect to any potential witnesses. Okay, Mr. Cox, my apologies. Go ahead.
All right. I guess just to return to what I was saying as to the motivation.
Yes, sir.
For the choices that were made. Choices that were made was that this was the type of criminal offense that was equivalent to a hate crime. And the choice was made that a statement should be sent that this type of conduct is intolerable in this community and that it should be subject to the ultimate penalty available under Texas law. If a member of an ethnic community has been targeted in such a manner because of their race or color of their skin, I do not think we would be questioning how the case should be handled. And the lesbian, gay, bisexual, and transgender community is not and should not be less deserving of the protection of Texas criminal law. Now, I've previously been forthright with the court regarding the deficiencies in how this case was handled. I think the remainder of my response ties into that, perhaps providing a bit further information. I've already mentioned that when this case was initially indicted, the evidence supporting the aspect of intentional killing in the course of a robbery and the fact that the victim was targeted were apparently disregarded. And it is my understanding, though I am not certain my understanding is correct, that actually this case was prepared for indictment by Adam Hines, not Mr. Briggs, although I might be wrong. Mr. Briggs is the head of the homicide unit. I believe, however, it was Mr. Hines who actually prepared and presented this to the grand jury. I could be wrong.
And Your Honor, I do have a few comments that I need to make as well. I will say that I believe Mr. Briggs, being the supervisor, had been in communication, obviously, with Mr. Hines and had been consulted on that decision. But nonetheless, my point is that I can tell you that Mr. Cox had come to me back in either at the very end of October or the very first few days of November, and asked me to look into the case, asked me to review the case to see what I thought, because he had questions about whether we should be going, seeking capital murder as opposed to murder. I reviewed the evidence in the case, and when I looked at the facts, I became very concerned about it because, number one, we have a witness saying the defendant was going around needing a specific amount of money for his family back in Juarez. The defendant then knows that the victim, Mr. Juan Flores Garcia, is a gay man who is easily targetable because he is gay, because being a member of that community, he operates his assignations, picks up men in the shadows. And so he was very vulnerable. The defendant targeted him and allowed himself to be picked up. I think, as I understand, well, I can't tell you what's in the defendant's head there beyond the fact that he apparently posed as a male prostitute in order to be picked up by the defendant, by the victim. And Mr. Flores Garcia took him to a secluded location, which was obviously the defendant's intent. We definitely have a video of them both getting out of the victim's truck. They go into the secluded location. We know that the physical evidence shows that the defendant was stabbed in the back. Most of the fatal wounds were in the back. Some of the wounds to the head area and the neck area, but it's very obvious that he was stabbed in the back in a kneeling position. And, the blood spray is where you would expect when he's kneeling. We know he's in a kneeling position when he's brutally stabbed 20 times, 19 or 20 times. One of those is, the stab wound could be 1 or 2. Regardless, whether it's 19 or 20, it's extremely brutal. And when the defendant then after he kills the victim, he takes the defendant's keys to his F-150 and his laptop, steals his stuff, and then takes off and sells the truck for $250. So to me, it's extremely clear that this was done for the purpose. It started out as a robbery and it was a murder in the course of a robbery. So capital murder is unquestionably the offense that should be charged.
Okay.
Yes.
And I'm sorry to have this a little bit disjointed, but I am taking so much issue, Mr. Ferguson, with what you're telling me right now, because if it was so abundantly clear as early as October that this was in no doubt in your mind with your two experienced attorneys' opinions reviewing this case, why I do not hear not one word from the DA's office that there is a pending reindictment, that nothing is expressed from the DA's office that there is not going to be the November 5th trial, the December 2nd trial. It's just continuance because we don't want mass. We don't have our witnesses. It has been mishandled. And I find it frankly very troubling that it is only at this late date in the state's objection to this motion to dismiss that somehow now we're worried about communities being targeted. Only now, after doing nothing for months. It is very, very difficult for both of you, Mr. Ferguson, Mr. Cox. And I hate to do this because it really is kind of just landing here now, but ultimately the responsibility is that of your office. Why is it now? Why is it on the verge of Mr. Gabaldon asserting his right for a speedy trial that I get a reindictment, a decision to seek the death penalty, and every other request that really puts the court in an impossible position? Because realistically, with the decisions you've made, the trial is I'm basically between a rock and a hard place. How we cannot proceed under the decisions that you all are making. And so what is coming into question and what the defense has brought to the court's attention is the manner in which this decision is made. And I am focusing on the two decisions. I cannot see, and I'm open to hear, we will stay here all afternoon and go beyond if needed, because I want to know, when you all are seeking the death penalty against an individual that is presumed innocent, how that decision goes from nothing to a penalty that is the most severe penalty that we have in our criminal justice system. And to have in the state's objection this overriding concern, which I think is a valid one in terms of protecting our community, seeking justice, but to pull those out last minute and somehow, I don't know how you rectify it in your decision-making, how your office has rectified it in your decision-making, to say, we blew the case off for 8 months, but now we're trying to protect whatever justice there is for victims, for the defendant, whatever it is. I don't know how you can rectify those two things.
Okay.
I don't.
And Your Honor, on that point, I'll say this. I can't turn back the clock and remedy how this case was handled before I came onto it. What my oath that I took as a prosecutor requires of me is that once I am involved in a case, I try to fix what's wrong with it. I try to do the right thing. I try to do justice by the community and the victim. So I can't go back to what was done before I became involved in this and rectify that.
I will remind the court, Judge.
Hold on, Ms. Butterworth.
And
so
the
then,
other,
so let me go back though, Mr. Cox, because I think we've kind of, in the written motions and response, and I think I know, I understand that part. I really do.
Yeah.
I hope you know that, I get it. I get it. I understand it for what it is. Let me go back to something I was bringing up though, that I'm kind of looking at this as being, two decisions, the re-indictment and then the decision on the death penalty. What, with respect to the decision to seek the death penalty, how does that, what was additional there that made that decision happen? I mean, I'm failing to see how we get that far.
And Your Honor,
Well-
that's part of that is what I was trying to address with the court.
Mhm.
Because I have a concern that this is being argued by the defense as if the decision was made as part of the state's motion for continuance. I can tell the court that when I looked at it, I suggested that we would want to run up the death penalty up the chain because of this being not just because of the brutal nature of the case, but because of the fact that the victim was targeted, and we have an epidemic of victimization of people in the LGBTQ community. So this was my take on it originally. And that was, I had no knowledge whatsoever, because I hadn't looked at anything other than the facts of the case, the evidence that we had. I wasn't even aware that we were unprepared on things. That wasn't what I was asked to look at. And I certainly saw it as something that we should be looking at the death penalty and considering it, because we need to draw a line in the sand. That was how I was thinking when I called Curtis back and said, look, this is obviously, as you thought, to me at least, it's obviously a capital case. And we should certainly be considering whether we want to ask for the death penalty, because I think it's certainly justified here.
But then they offered
Hold
this
on,
kid a
hold on,
PR
Ms.
bond.
Butter, yeah, hold on, I'm getting there, Ms. Butterworth. So Mr. Ferguson, were you also consulted and in agreement with the PR bond, a full PR bond?
I was not, Your Honor. I was not even aware of any of the proceedings until I think after the hearing. I guess it was on the 15th. I'm pretty sure that was the date. I became aware that this was becoming extremely contentious. And I joined in at that point to try to assist Mr. Cox on dealing and handling preparation in this part of the case. But what I can tell you is that my discussions were prior to that.
So are you saying your involvement was contingent upon the contention or the pushback from the defense counsel in terms of their opposition to a continuance and their motion for speedy trial?
No, Your Honor. My only concern was that I wanted to make sure that we had enough time to make the decision on whether or not to seek the death penalty. Because if we do not make that decision before the date we start trial, then we can't make that decision. That decision's decided for us unless we decide to seek the death penalty. I really did not want to make that decision hastily. But
And that is an opinion that you formed early in October, that this was a death penalty case, in your opinion?
no, not early in October, Your Honor. it was either the very end of October or the beginning of November when I was asked to actually look into it.
All right.
So,
Mr. Cox, to the extent we can go back to you if you have something else.
sorry.
I do.
Yes, sir.
The defense has made an issue about the bond issue that came up at an earlier hearing, and I think Ms. Butterworth was just about to return to that. And I want to relate my reasoning in regard to the decisions I made at that hearing, and that is simply this. First was, we were asking for a continuance, and I was saying that the state was around announcing it was not ready. The first thing I want to point out is that we are no longer saying we're not ready. We'll start on the 2nd. And under the statute, all you have to have is 50 jurors show up on a capital case. I mean, I filed a motion for the special venere writ, but that's discretionary on the court. I filed a demand for individual voir dire. That is the right of either party on a death penalty case, but the statute that governs summoning a jury basically says that you only have to have 50 people. Or certainly it mentions that if 100 people have been called that week, you can proceed. And I acknowledge a variety of things were not done. Your discovery order requires the statement of a defendant to be made available to the defense 120 days before the set trial date. I have always acknowledged that was not done. Frankly, it doesn't matter when the translation was filed. I could have brought in an interpreter and had the statement translated as it played to the jury, which I have done in trials before. But the thing that was undeniably clear long before I became involved in the case was that 120-day deadline on making the defendant's statement available to the defense had definitely not been met. And so the statement was not usable under the terms of your discovery order.
Mm-hmm.
And so because the state was announcing that it was not ready, which is in effect simply a statement that we are asking for more time. But there is always the knowledge on the part of anyone with any experience in criminal law that the state can deny a continuance. Because the defendant is presumed innocent until proven guilty beyond reasonable doubt, it did not seem to me supportable to be arguing that when the state is saying that it is not as ready as it would like to be for this trial setting, and therefore we are asking for more time. It did not seem supportable to me to take the position that the defendant should not be subject to consideration for a bond modification. And as to the release on personal recognizance, I would state that I think we all know that a defendant being released from jail is not an admission of lack of dangerousness, because we have defendants who are on surety bonds who, if they post the bond or a bondsman's fee, they are released regardless of how dangerous they might be. And that was also part of my consideration. Okay. This defendant being released from jail is not a statement that he is not dangerous. It is a statement that he has satisfied the conditions that have been placed upon him. And one other aspect of consideration was the evidence in this case shows that the offense was targeted and premeditated. That shows a high level of intellectual capacity and functioning, and therefore the ability of this defendant to conform his behavior while he is out on a PR bond for a couple of reasons. I have no doubt, based on my experience as both a prosecutor and a defense attorney, that the lawyers would tell him, you better be on your best behavior while you're out on bond, because everybody's watching and you're still facing the charge. And secondly, the defendant, by the facts of the cases shown by the evidence, has shown that he can premeditate and plan and execute his plan, and therefore he can conform his behavior while he is out on bond and while he is under the supervision of the PR bond system and the criminal justice system in this county. And so my statement that I would not oppose a release on PR bond was not a statement that he isn't dangerous. It was a statement that I believed he would conform his behavior until his case went to trial.
That's, Mr. Cox, that's very troubling. That is very troubling for me to get my head around, because it is, I understand how on the one hand were acknowledging, I guess, the difficulties the state had in diligently prosecuting the case to be ready for trial. But I simply can't get what thought process would get me to the point where I would say, well, yeah, we understand, especially with the indication that you would be seeking a potential reindictment and potentially seeking the death penalty. But we think he can follow PR bond conditions, Judge, if you let him out on a straight PR bond. I understand what you're telling me, that there's no correlation, but I don't understand the thought process behind saying we're okay with letting him out on PR bond, because basically you weren't ready for trial. So that's a tough one, Mr. Cox, but go ahead.
And Your Honor, that is my honest recounting of my reasoning. That is my outlook on things. Some people may understand that, others may not. And I'm not asking you to wrap your head around that or not. That is simply my reasoning at that time. It has been my reasoning pretty much all of my career as a prosecutor.
I understand.
I mean, is it ideal? No.
Well,
But
I
I
guess
believe in
the
the
reason,
presumption.
hold on, Mr. Cox, the reason I bring that up is because I'm also hearing and seeing in the motion this, argument to the court about the safety of targeted communities here in our community. And I can't put those two together. I can't, it's difficult for me to understand the basis of that argument. I'm not saying in and of itself, it's not a worthy concern. What I'm saying is, you're saying in your objections that, let me pull up the motion, that because of the nature of the crime, or the allegations, there are targeted communities that you're very concerned about, but you were okay with a PR bond and some PR bond conditions. It's very difficult, Mr. Cox.
Well, and Your Honor, I'll put it this way. I'm coming at this case. Let me preface this. In all the years I've been a prosecutor, I have concluded that the state goes off track when it starts focusing more on preventing future conduct than it does on holding someone accountable for what they've done in the past. And the way I look at this case focuses on what the defendant is alleged to have done and what the evidence indicates that we can prove. But I will also tell you that I take the presumption of innocence deadly seriously, and this defendant is presumed innocent. And I have tried more than 100 cases to a verdict, and I know full well that because I look at something some way, a jury may not agree with me. And on that occasion, if I'm coming here and saying, there's a lot that hasn't been done, we're not ready, we're not as ready as I'd like to be, I have a real problem if I'm having to say that to the court, to also say, but we're not ready, but you should keep him locked up in those cells at the annex. So that was a decision I made, and that's why I made it. And that is fully debatable, and I expect it's going to be.
Yeah.
But that was what was going on in my head. This is not a statement that, gosh, I don't think that what he did is so bad it deserves the death penalty. I thought that from the very beginning. The type of behavior described by this case has been going on the entirety of my life. I first started hearing stories and seeing instances of this 40 years ago when I was an undergrad in college. You know, people who will go out to the gay bars, intentionally pick up people, take them out to an alley or take them to a secluded place and beat them or kill them. I have a cousin who was treated that way in Colorado. I have had friends who've been treated that way. This has been going on all of my life, all of our lives, and it is time for it to stop. And so that is where I'm coming from in my decision-making on this case. I thought this case was worthy of re-indictment, the death penalty, as soon as I read the affidavit. But I had 15 years of experience, and I know that there have been times I've read affidavits and they have apparently little relationship to what the rest of the case file shows. And so I took some time to look at the rest of the case file and see if I had any concerns. And in the end, I did not. And beyond that, I simply want to point out that we'll be ready to start jury selection on June 2nd. You know, we will abide by the restrictions imposed by your standard discovery order and the things that were not done in accordance with the timelines in that order. That includes that the defendant's statement is no longer usable by us. That includes that, yes, the notice of extraneous offenses was not timely filed. It wasn't particularly extensive or striking to begin with. The Texas law doesn't require a laundry list of bad actions for a jury to find that a defendant should be subject to the death penalty. Texas law says that one instance can be sufficient. And in fact, as I have mentioned, potential jurors can be struck if they are unable to say that they could consider the simple facts of the offense as being enough to answer question number one, yes. You know, we're not asking for any more time. We're not doing this to penalize the defendant for asking for his trial on December 2nd. We're ready to start jury selection on December 2nd. And we're ready to start with however many people come in response to the panel that you summoned. And as I've said, my reading of the Code of Criminal Procedures indicates that the number 50 is what's mentioned.
All right. Ms. Butterworth?
Judge, they weren't ready. And they were announcing not ready. And it was clear they were not ready when these decisions were being made. And that is what we're asking the court to look at, the context of which the re-indictment occurred and the context in which the notice to seek death. I still contend all day long. I don't know what I'm hearing. I'm hearing Mr. Cox say he stands by his decision to seek death, but he thinks that that my client will conform with a PR bond and will abide by the rules of a PR bond. How in the world could you say both things at the same time? I believe that they are in a position where they have been exposed. My client is sitting here, Judge, where they refiled and they're telling him and his family that they're trying to put him to death. I don't have words other than it's garbage. It's being said after the fact. It flies in the face of every question you're asking, Judge. When you're asking for just, can I have a logical explanation, and you're not getting any because they aren't there. And that's why we're asking for you to dismiss this case based on the motion that we filed. If the state of Texas ever decided to put the work in that they need to do to get maybe their DPS back, to find witnesses, to look at the case more, they could come back and re-indict on murder when they're ready, when they're educated, when the decision's being made intelligently. But I believe that we have proven absolutely by a preponderance of evidence why this went off the rails, and it was to delay trial. And we're asking for our motion to be granted.
Your Honor, if I may clarify one thing that I noticed about the motion, And
Yes, sir.
all of the case law that defense counsel is using to support this, number one, all of the case law defense counsel is talking about is post-trial, not pretrial procedures. Number two, retaliation. I mean, they have to prove that, and under the case law, they have to prove that it was done for the purpose of punishing the defendant for exercising his right to, I guess, a speedy trial. That's my guess of my reading of their motion.
That's
Not a-
exactly
It's
correct.
not a guess, it's there, yes.
And so, so we're not talking about, now, number one, I would argue it was certainly not done for purposes of delay, but regardless, that's not really the standard. The standard is to punish the defendant or to retaliate to the defendant for exercising a right. And there's absolutely no evidence there of that.
So I would just refer you back to the motion and the previous argument by defense counsel. I believe that's exactly what they're asserting. So before I move on to maybe flesh some things out with you all, with respect to Mr. Briggs and the other subpoenaed witnesses, subpoenaed individuals, is anybody requesting they come in? Do you need to present anything? And I believe there were motions to quash us to at least two of those witnesses.
Judge, I'll respond initially. They were our motions. Hang on.
Can you start again, Judge? I'll
Respond initially.
Sure. They were our motions. The defendant subpoenaed Mr. Briggs. I gave a recitation of what I believe Mr. Briggs would sponsor, the relevance that he has. If Mr. Cox wants to agree that the facts that I would offer through Mr. Briggs are correct, that he was part of the process that initially handled the case where the decision was made with the same exact evidence that's available as of today, where the decision was made to seek an indictment on murder, that Mr. Briggs is the supervisor of the homicide section right now, that he's the lead attorney handling the Walmart case. Obviously, that shows how entrusted he is by the office. I was going to get into his lengthy resume, how many death penalty cases he's tried, the types of death penalty cases, that those facts that warranted a decision to seek death. But really the essence is that he, Mr. John Briggs, believed this to be a murder. No evidence has changed. And then I think it's super important to note that he wasn't consulted by these men on the screen as to his charging decision. No conversation, whether it was murder or capital murder, why not capital murder, or a discussion about seeking the death penalty. And that is why, unfortunately, I had to drag Mr. Briggs into this. But if Mr. Cox would agree that that is all correct, then he would not need to testify today.
I will agree that he is the head of the homicide unit. He must have in some way been involved in the preparation of this case when it was initially indicted. I'm not going to dispute that he is an experienced trial lawyer and has handled a large number of murder cases. So no, I'm not going to dispute those things.
And then, of course, I need an agreement that he was not contacted on this decision to re-indict.
I very much did not contact him. Frankly, I did not particularly care what his point of view was, because it was clear to me that he had been part of a process which had overlooked very significant aspects of the evidence. So no, I did not feel a need to consult with him in that regard, because I felt that that was part of the mishandling of the case.
And he is the lead attorney on the Walmart case.
I'm not going to dispute that.
Although, Your Honor, I will object that that's kind of irrelevant.
I don't believe it is. I think it continues to show the timing of events and how we're trying to prove that this was done for purposes of delay.
So
And then
with respect, hold on, Ms. Butterworth, with respect to whatever prospective information, it doesn't sound to me like we have a full agreement. And so Mr. Briggs is here. I do know that the state has filed a motion to quash that subpoena. And so Mr. Ferguson or Mr. Cox, who is handling the motion to quash?
Renee,
It's Mr. Flores.
I'm sorry?
I believe it's Mr. Flores, Your Honor.
That would be me, Your Honor.
Okay. I'm getting a note here from, we need to take a 5-minute break. So we will handle the motion to quash after that break.
Judge, whenever you're ready.
All righty. Okay. Everybody ready?
And Your Honor, I will
Yes.
say that during the 5 minutes, I thought in more detail about what Ms. Butterworth is asking me to agree to, and having thought about it with a little bit more deliberation, I will agree to that.
Okay. All right. And so Ms. Butterworth, you're not requiring Mr. Briggs for any other matter? Is that right?
No, Your Honor, he's off the hook.
Okay. All right. What
Your
about
Honor.
Mr. Herrera? I didn't really hear anything. I just know that there is, thank you, Mr. Briggs, you are excused. With respect to Mr. Herrera, I didn't hear anything specifically, but anything on his
And
end?
Judge, we will go ahead. We're not going to call Mr. Herrera at this point. I believe what initially we were going to cover with him, if the court will take judicial notice of the court's file. And then more importantly, when I get copies of the transcripts of all of these hearings, I believe that what we were going to walk through step by step with him should be covered for purposes of the record.
Okay. All righty. So if Mr. Herrera is here, then he can be excused as well. What about the detective or Officer Reyes?
So the detective, I don't believe the state has filed a motion to quash on him. I don't believe they are entitled to. I would like for him to testify, especially regarding the recitation of these new facts, that this was a hate crime based on the victim being gay. I can either, however the court would like to do, I can either just respond to that with my own recitation of what the facts are, or I can get them in with the detective.
So I would like the detective to come in, if we can go ahead and bring him in from the waiting room. I don't know if I have that.
Yes, Judge, I'll bring him.
Judge, while you're doing that, I thank you. I understand I've been excused. Is it okay if I remain logged in? I just kind of want to listen in and see kind of where stuff goes. Is that okay if I just stay? I'm going to turn off the camera and mute.
Absolutely.
Okay, thank you, Judge.
Thanks.
Your Honor, this is
Okay,
Renee
is
Flores.
it Officer Grease? Is that who it is? If you could unmute, please, and did we lose him?
You know, I believe he did log off, Judge.
Your Honor, this is
can we hear
Renee
Mr.
Flores. Okay.
Mr. Flores, please select the English channel if you're speaking. I can't hear you.
Your Honor, this is Renee Flores. Can you hear me now?
Yes, sir.
Your Honor, my purpose for being on this here in this hearing was on the response to the motion to quash. May I, since Mr. Briggs and Mr. Herrera will not be
You
called.
may be excused.
Thank you, Your Honor. Have
Thank
a good day, ma'am.
Mhm.
So he's coming back on.
Okay. Okay, sir, this is Judge Alyssa Perez. we had taken a quick break, and I know I had seen you in the waiting room. You were subpoenaed today for a hearing, so I am going to swear you in. Can you hear me okay?
Yes, ma'am.
Okay, Mr. Dries, I'm going to ask that you select the English. You're going to see an interpreter function on the bottom. If you will select English, please, because I can't hear you.
Okay.
Perfect. I can hear you now. Sir,
Yes, ma'am.
do you please raise your right hand? You swear or affirm that any testimony you provide will be the truth and the whole truth, sir.
I do, ma'am.
Thank you very much. You can lower your hand and state your name for the record.
My name is Juan Reyes Ruiz.
Ms. Butterworth, you may proceed.
Thank you, Judge. And thank you, Detective, for your patience. We are just getting to your portion of this particular hearing. So can you please, for the record, just state how you are employed?
Yes, ma'am. I am currently employed as a police detective with the El Paso Police Department.
Okay, and your assignment would specifically be with crimes against persons, is that correct?
That's correct, ma'am.
Okay, and were you, I guess for lack of a better word, the case agent assigned to this particular case?
Yes, ma'am.
Okay. In your investigation, would you agree with me that the majority of the evidence that you had regarding the probable cause to write up the affidavit, you had done most of the investigation after speaking to my client, Mr. Gabaldon? And what I mean by that is there wasn't months of continued investigation in this particular case. Is that correct?
That's correct.
Okay. And I'm going to start backwards for a second. I want to make sure that that we understand the answers to these questions. In the last couple of months, we'll say October or November, had you ever been contacted by anyone in the DA's office, I guess specifically by Mr. Cox or Mr. Ferguson, to do any additional work on this particular case?
No, I have not.
Had you ever been contacted by these two individuals just for a pre-trial for them to talk to you regarding the investigation, the work you've done, or any questions that they had?
No, ma'am.
Had you been contacted in October or November and made aware by either Mr. Cox or Mr. Ferguson that there was a jury trial coming up in this particular case?
No, ma'am.
Had you received a subpoena in this particular case for a jury trial for either the November 5th setting or the continued December 2nd setting?
No, I have not.
Okay. Mr. or Detective, you personally interviewed my client, is that correct?
That's correct, ma'am.
Okay. And during the interview, at some point, I guess the interview begins where you are questioning him regarding his involvement in this particular case. Is that fair to say?
Yes, ma'am.
And eventually, he denies being involved at all. But eventually, after questioning, he ultimately tells you that he did commit this offense. Is that correct?
That's correct.
And before he tells you how it happened, he vomited. Is that correct?
Yes, ma'am.
And was crying.
Yes.
Crying so hard that you had to ask him to drink water or to stop crying in order for you to be able to understand what he was saying. Is that correct?
I was just trying to make sure he was okay to talk to me.
Okay. And when he eventually tells you what happens, he tells you that he was picked up by the victim when the victim was driving his Ford F-150 white truck. Is that correct?
That's correct.
And that I believe he tells you that he was picked up downtown. Is that correct?
Yes, ma'am.
And the victim tells you, I believe he is either 19 or 20 years old at the time the statement is given. Do you remember his exact age? I know he's had a birthday since. More or less, 19 or 20.
More or less, yes. I believe 20, but I'm not completely
Okay.
sure.
And he tells you that he is married and he has a wife and a baby that live in Juarez, and that his wife was expecting her second child. He tells you this in the interview. Is that correct?
That's correct.
He explains to you that he works any possible jobs he can get to try to provide for his family. He tells you that in the interview, correct?
Correct.
And that eventually when he breaks down after vomiting and sobbing to tell you what happened, he tells you that he's picked up, and because he is so poor, he agrees to be solicited by Mr. Flores in this case to be paid, I believe it was $20. And the agreement was for Mr. Flores to perform oral sex on my client. Is that correct?
Yes, ma'am.
And he continues to tell you that it is Mr. Flores driving the truck, and that it is Mr. Flores who says that he wants to take the defendant, my client, back to his home. Is that correct?
Yes, ma'am.
And that during this time that the victim, the alleged victim in this case, goes to his home, and they go, I believe he mentions that the cameras are turned off by Mr. Flores. Is that correct?
I don't recall that part.
That's okay. That's okay. Bottom line is, he is in his own home. You did learn, did you not? You did learn that this place has lots of video surveillance cameras, correct?
That's correct. Yes.
Okay. And so Mr. Flores takes my 20-year-old client, who he had hired for sex, into his home. And then my client tells you that at some point he wants to take it farther. Do you remember that part?
Yes.
That he wants to, and I don't want to get into too much of this, but basically he wants to put a broom in my client's anus. He's sobbing as he tells you this. Is that correct?
That's correct.
And he tells you that at some point the victim is the one that produces a knife and asks or demands that my client continue to go and continue the sexual acts. Is that correct?
That's correct.
Okay. And then at some point, my client tells you that he is able to take the knife away. And my client tells you that he stabs the alleged victim while he is on his knees performing oral sex. Do you remember that part?
Mm-hmm.
And so my client explains that the victim is on his knees during this, as the facts are presented from his perspective, as he's being raped. Agree?
I believe so.
Okay. And then he tells you that he flees the scene and takes the alleged victim's truck and drives it a couple blocks away and parks it. Is that correct?
That's correct.
And that is where the truck was found.
Yes, a couple of blocks down.
And the truck wasn't being hidden at all. The license plate was still on there, correct?
That's correct.
No tarp covering this truck?
No,
correct?
ma'am.
Okay. And then he tells you that he goes to Luis Bueno's apartment and tells him what happened. Is that correct?
That's correct.
And that he gives Mr. Bueno the keys to this Ford F-150 extended cab truck. Mr. Bueno then gives him $200 and then he leaves to go to Mexico. Is that correct?
I believe so.
I'm going to catch you off guard, but más o menos, detective, what do you think that 2013 Ford F-150 extended truck is worth?
You know what? I'm not an expert on vehicles values, but
Certainly
yeah.
a heck of a lot more than $200 thrown his way. Is that correct?
Yeah, I could agree to that.
Okay. And when you made your charging decision, you spoke to my client, this 20-year-old kid. Is that
Yes.
correct?
Yes, ma'am.
And then interviewed whatever other witnesses that were interviewed, saw the crime scene as it was, collaborated with your fellow detectives. Who was your supervisor on this case?
My supervisor on the case, it was Sergeant Camacho.
Okay, with a tremendous reputation as well as being an excellent police officer. Would you agree?
Yes, ma'am.
Okay. And with all of that information, but most importantly, your information of speaking to the defendant, you made a decision to charge him with murder. Is that how you drafted your complaint affidavit?
Yes, ma'am.
Did you believe, detective, that all of this went down with the premeditated thought by my client to steal that truck? And that's how this went down, and that's why he murdered him?
That is not what the investigation showed.
All right. Thank you, detective. I pass the witness.
Detective, let me ask you, were you aware of the statement of Priscilla Valenzuela?
Yes, sir.
Okay. And so you were aware that she said that Mr. Gabaldon had talked to Ms. Louis Bueno that evening about needing money?
I believe so, sir. I don't know.
And then he left the apartment and returned approximately an hour later and gave Mr. Bueno the keys to the victim's truck in return for $200.
You know what? I will have to review Miss Valenzuela's statement again.
Okay, so that wasn't on your mind when you were deciding how this case should be charged?
No, sir.
Okay. Would you say, as you hear it now, that a fact pattern in which somebody goes to a person and says, I need money to support my family, what should I do? Comes back an hour later and sells him the keys to a truck for $200. Would you characterize that as a robbery?
Can you repeat the question?
Okay. When you have a fact pattern where someone goes to a person and says, I need money, leaves, seeks out a person who he knows has a truck, kills that person and takes the truck, goes back to the person he talked to about needing money and trades him the keys to the truck for $200, would that not strike you as being a robbery?
You know what? I mean, I wasn't there. I don't know exactly what happened, but at first, that's not what the investigation showed.
Okay, and yet Priscilla Valenzuela's statement, which says exactly those things, is part of the offense report, is it not?
It is, sir.
Okay. Is it fair to say that that statement was either overlooked or disregarded in deciding what the investigation showed?
If I'm not mistaken, I believe we located Miss Priscilla after the fact, after Mr. Gabaldon was arrested.
Okay, so then it would be fair to say that you arrested Mr. Gabaldon simply on the basis of his statement and without reference to the full facts eventually uncovered by the investigation. Would that be fair to say?
We arrested Mr. Gabaldon what the investigation showed at the time.
Okay. So you arrested him before you were finished conducting the investigation, did you not?
We had probable cause to believe that the offense of murder had happened.
Okay. And yet you later uncovered facts which indicated that there had apparently been a robbery which took place in connection with the murder, did you not, when you talked to Ms. Valenzuela?
You could say that.
Okay. But you'd already arrested Mr. Gabaldon and decided that all this amounted to was a murder before you had all of the evidence you eventually uncovered. Is that not correct?
That's not correct, sir.
Okay, you're saying that you arrested him and charged him with murder before you talked to Ms. Valenzuela.
Yes, sir.
Okay.
And that's what the investigation showed.
So your charging decision was based upon incomplete information, was it not?
We attempted to locate Miss Priscilla, and unfortunately, this is how these cases go. You know, sometimes we're gonna have access to a witness immediately. There has to be legwork done, and we're supposed to, I mean, we need to work to locate them. But at the time Mr. Gabaldon was arrested, we had probable cause for the offense of murder.
Okay. And so you went with what you had at the time he was arrested, even though the investigation wasn't complete.
No, sir.
Okay. Would you agree with me the fact that you continued to uncover evidence after Mr. Gabaldon had been arrested and an arrest warrant affidavit presented? Would you agree with me that he was arrested and charged by the police before the police had finished their investigation?
Yes, I'll agree to that.
Okay. And so the charging decision of the police was based upon incomplete information, was it not? Because your investigation uncovered further information after he had been arrested and charged.
I mean, on any investigation, there's some follow-ups to do. On this case, we still needed to talk to Miss Priscilla.
And after you talked to her, you just included the report in the file and submitted it to the DA's office.
That's correct.
Was her statement in the file at the time the case was initially submitted to the DA's office for indictment?
I don't recall that, sir.
Okay. Is it possible that it was not at the time that the case was submitted for indictment?
It might be possible.
Okay, so it is possible that the case which was initially submitted to the DA's office did not contain all of the information that the offense report contained 6 months later.
Yes, sir, but the statement is uploaded into WebRMS immediately after it's taken.
But that doesn't mean that it's uploaded into WebRMS at the time that the case is presented to the state or that the state initially indicts it, does it?
I don't believe so.
No further questions.
Okay.
Just a brief redirect. Detective, you were the one who took Miss Priscilla Valenzuela's statement. Is that correct?
Yes, ma'am.
And after interviewing her, did you believe that that changed the offense for what Mr. Gabaldon should be charged with?
No, ma'am.
Not at all.
No, ma'am.
Nothing in that statement made you believe that this was an intentional seeking of an elderly gay man in order to steal his truck and somehow con him into going to his own home. There's nothing like that is taken from Ms. Valenzuela's statement. Is that correct?
Yeah, that's not what the investigation showed.
Okay. No further questions.
No further questions, Your Honor.
Thank you very much. Thank you, Detective. You are excused from this hearing. Thank you for your time.
Thank you, ma'am. Have a good day.
You too. Okay, I just wanted to make sure that we took care of kind of all the last minute ins and outs. And so I would like to ask the parties, because it now has been represented today by the state, and I'm not ignoring the motion to dismiss, but there has now been a representation by the state that they will be prepared to go to trial on Thursday as with the panels that we have for those days. My question would be, with respect to your request for individual voir dire, as I read it, is not discretionary once it has been requested by either party. I'm asking if you all are continuing to request individual voir dire, or if in your announcement of ready today to go to trial with the panels that we have, that you are abandoning that request. I'm not asking you to do it. It's just the way I read 3517, that once either party has made that request, I do not have that discretion.
Yeah, and that one request I'm not abandoning. I will abide by all the limitations imposed upon us in regard to the notice of extraneous, in regard to not asking witnesses to express as expert opinions, although I believe that those same witnesses can certainly testify as to facts they themselves have witnessed and perceived. I'll abide by all of those. We are ready to start jury selection on the 2nd, but I am standing by the demand for individual voir dire. The judge does have the ability to set whatever time limit that the judge thinks is appropriate on the individual voir dire. But I am not relinquishing the demand for individual voir dire.
Okay. So, the problem for me here is twofold. I have some concerns, and this is not speaking to the substance of the motion to dismiss and the objection. However, I'm just trying to think this one through and see practically where that puts us. And so if you're proceeding on the motion to dismiss, which you are, Ms. Butterworth, that ultimately, if that were granted, I'm assuming there is going to be an appeal, and whatever time that takes, and your client is in custody. And I'm not sure how efficiently, if it were denied, we can actually go forward with the panel on the 2nd. And so I'm open to what the state is proposing we could do in terms of the 2 panels that we have. I frankly think that based on the request, which I'm not saying they're not valid, Mr. Cox, the individual voir dire, literally the stakes went up quite a bit once the state filed their notice of seeking the death penalty. And so I certainly don't take that lightly, but I don't know how we can do that productively, fairly, efficiently with the panels as we are set up under the COVID protocol. And I am asking not just for Mr. Cox, but Ms. Butterworth, again, not telling you what the decision is on the motion to dismiss, but how would we be able to do that?
Well, I think the statute is clear that the procedure is required is that the judge addresses a panel as a whole about the enumerated issues, and then the parties question the witnesses individually outside the presence of the other members of the prospective panel, in accordance with whatever time frame that the court allows. I think, frankly, that not only is that can be accomplished with the current jury panel setup, because we summon 57 people as a standard now. But then, frankly, in terms of the pandemic, it is probably safer to have fewer people in the room. It's probably safer than if you have a whole panel present for a couple of hours or more with 57 people all in the same room, plus the court staff and the lawyers. And so I think that can be done. And then if the panels that are available are not sufficient in number after strikes for cause, I believe you have another 170 people lined up a week later on the 9th, and you could enlist those panels and just continue.
And Your Honor, if I may, I think the defense's concerns are mostly addressed by the fact that whatever has to be done in order to get us a panel, we will stipulate that we are starting the trial on December the 2nd.
And that does not, thank you, Mr. Ferguson, that doesn't address any of my concerns. None whatsoever. My kid is sitting there now suddenly looking at the death penalty, to even answer your question of how this play out, there should be no logical answer, because it's insane what has happened in this particular case. How do we intelligently argue in such short notice, where this case has gone the direction it does, how we begin on the 2nd? The answer is, it's a joke. It's a facade. It's exactly why we filed this motion to dismiss. It was for purposes of delay, and to now, I mean, it flies in the sense of anything that's happened in this courthouse, where we pick a jury on December 2nd, and the state gives us notice that it reindicted and is seeking the death penalty a week before. It's precisely why we filed this motion. So it doesn't address any of our concerns. And I will continue to scream that this is not fair to my client. This is not fair to Mr. Gabaldon. What has happened? What is going on? While he sits there, it's wrong, it's wrong, it's wrong. And he should be protected from this disgusting abuse of power.
So I know this has been a very long hearing, and certainly what it is at issue on the motion to dismiss is very serious, because in no way, just as the state has explained to the court the difficulty and the seriousness of the decisions that they have made in how this case has proceeded, it also weighs very heavily on the court, considering the motion that has been filed by defense. The problem is, because of the timetable and the timing, the short turnaround time, it makes it, it puts the court under extreme pressure. And I know you all have provided, additional information today. I appreciate all the additional information that has gone back, not only through the pleadings, but just in hearing from you all today, because this is, the defense's motion is something that, if I was reading the pleadings and seriously, Ms. Butterworth described it exactly as how it fell on the court, which is, a gut instinct based on what was presented in the motions. And so I appreciate you all filling in some of that, some of the questions. But it is a decision that the court can't rush, simple as that. And what that means for me is that I know the defense has also, through previous, obviously the motion for speedy trial, has asked, and I granted the fact that there will be no continuances, but there's a new issue, I think, an intervening issue, and the court needs time to make that decision. What I think that ultimately is going to mean, because I'm not going to have that decision for you by December 2nd. I have received some case law from Ms. Butterworth. I believe you provided the Hill case, and then there was, I believe, Neal, some of those cited. There is, I read through the cases, and Mr. Ferguson, your point about, post-trial or post-conviction, that resonated with me when I read the case law as well. But it also, in reading the case law, delineated in some of those cases what the proper steps would be. And it appears to me that the defense has done that. They have presented in timely, with good argument, many of the aspects of both prongs of that test. But I don't want to, because I just received your response this morning, I'm not going to leave it at that. Time is a factor here, but I'm not going to let that rush a decision that may not be favorable to you all. Okay. And so I need a full brief of any, literally, I don't need 40 cases, but 2 very on point cases as to, based on what has transpired today, why this case shouldn't be dismissed. I've heard the arguments made today, and I'm well aware of what my discretion or responsibilities are in terms of the information received by the court. I won't make that decision lightly. I assure you of that. It just does not, I don't see it fitting with the timetable that we have of the December 2nd trial. And so I don't know how quickly the state can provide additional case law on their position. I know there's some cited, but quite frankly, I have not had the time from 8:30 this morning when I received the courtesy copy from you all to actually look at the cases. And it's not fair to anyone to be rushing it like this. And ultimately, you know, we're in this position because of the late decision making on the state's part. So Ms. Butterworth, do you have any comments on that? Let me tell you where I am with this. Is I just can't see December 2nd working out in terms of an actual trial setting. And I think that's really jumping over what the primary issue is for you all, which is the motion to dismiss. Ultimately, if it's denied, we're going to have issues because of the manner in which I think we would have to then basically start from scratch on a timetable. And we have the outstanding motion for speedy trial. I mean, I'm going to give the state, let's see. Till December 3rd to provide their brief. Ms. Butterworth, to the extent you need to respond to that or have anything additional to add in terms of any case law or additional argument, anything that has included some information from today, you will have until the 10th of December, so that is a full week. I will have a decision based on those briefs, unless you all require a hearing on the 13th. Well, I think we should just anticipate a hearing on December 13th. Let me look at the calendar. December 13th, looks like we're clear. We're going to shoot for 10 a.m. I will expect that everything will be briefed up until that point. So we're not going to have a 4-hour hearing like we did today, but that will be the hearing and you'll have your decision no later than the following day. In terms of a trial date for now, we have January. I mean, I think this might be pointless because if we get past the motion to dismiss, and the case, if the motion to dismiss is denied, then we will need a totally different timetable. But for now, we will have a backup date of January 14th. And the reason I picked that date is because we have 2 panels as we would have for the December 2nd date. In the interim, again, if there are any motions that need to be heard. Anticipate they will be heard on December 13th as well. Please file them and forward them to the court so they can be set. Is there anything further, defense or state?
Your Honor, just so that I am not making this, our deadline is December 3rd, which is this Friday.
That's correct. That's
Very
correct.
good.
Ms. Butterworth?
Nothing further from the defense, Judge.
Thank you very much. Then we will see you at the next setting. I'll anticipate receiving the filings from each of you. Thank you very much. We are adjourned on this matter. Thank you, Mr. Gabaldon. Ms. Noyola, thank you very much for your assistance today.